very good afternoon, everyone, and thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting with us patiently. Whilst you're waiting, we would like to share a short video with you from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Within and Beyond the Will, Strategies to Prevent Family Feud. My name is Kirthika Padmanapan, and I am an associate here at Quine Associates. I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and a little bit about what we do. Quine Associates is a mid-sized law firm which was founded in 1985 by Dato' Quine. Our able team today comprises of 29 lawyers and a support team of 28. Dato' Ma today is a consultant with the firm following his retirement from the Court of Appeal in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of the MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. However, since the COVID-19 MCO, we have moved our talks online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Our speakers for today are Chong Chieh and Daphne Rethual. Allow me to introduce Gan. He is a partner in our dispute resolution department. He was admitted to the Malaysian bar in 2009 and practices a wide variety of areas, including general litigation, will writing, probate and administration, as well as contentious probate litigation. Next, we have Daphne, who is a senior associate in our dispute resolution and individuals and families department. She was admitted to the Malaysian bar in 2019 and practices areas such as general litigation, joint management body disputes, and contentious probate litigation. We will also be having a Q&A session at the end of this talk, so do please post any questions you may have in the Q&A chat box at the bottom of your screen. The talk points today are estate planning and administration, disagreements over enforcing wills, conflicts arising from estate administration, and strategies for preventing and resolving estate disputes. I will now pass over the time to Gan. Over to you, Gan.
Thank you so much, Kirthika, for the warm welcome, and also big thank you to all participants for taking your precious time in attending today's talk. I will briefly be sharing what is estate planning and estate administration, and then I will proceed to discuss cases over disagreements on enforcing wills. So what estate planning really is, I have made here 3 key points to take note when it comes to estate planning. So estate planning basically is making arrangements in terms of your assets and how do you achieve your desired goal in respect of distribution of the assets and also in terms of administering the assets. So assets here could be your movable properties or even your immovable properties. And this is a simple explanation on estate planning. Whereas for estate administration, in this context, it means how do you actually administer the estate and what are the tools available to administer the estate. So as I mentioned earlier, when it comes to estate planning, it doesn't necessarily mean that you can only consider your planning of the assets or making arrangements of the assets upon your demise. Estate planning can also occur while you are still alive. So here in terms of estate administration, so upon death, if you have a will, your executor will apply for probate. If without a will, or if you pass on intestate, your administrator can apply for something called the letters of administration. Estate administration can also consist of trust. Trust here could be what we usually know like a living trust, or trust could also be a testamentary trust, which means a trust that is incorporated into a will. It could also be a trust which has been formed to perform certain objective. Another part of estate administration would also fall under the Small Estate Distribution Act of 1955 or under Amanah Raya. In a case where it falls under Small Estate Distribution Act, is where the property you have movable and also partly immovable properties, which is worth not more than 2 million. And you can actually go to the land office or the land administration to actually get it administered. Or if you have solely movable properties, you can actually go to Amanah Raya too. But in this context, and for the purpose of today's discussion and sharing, we will focus more on the probate and also letters administration. Do note that the position in the Peninsular Malaysia is a bit different from the Sabah and Sarawak scenario. So in Sabah and Sarawak, they do have certain acts governing their estate administration. But however, the principles are equally applicable in both the Peninsula and also Sabah Sarawak. When it comes to the legal framework, we have the Wills Act, which governs the drafting of the will and how, or the formalities of the will, how a will should actually looks like. And then we have the Rules of Court. Rules of Court is pertaining to the application to court and what are the procedure to follow when it comes to making the application to the court. The Probate Administration Act is in respect of how probate are to be administered, and the Distribution Act comes when the deceased dies intestate. So you have the Distribution Act in terms of the percentage of distributing the assets. So now we'll get into the disagreements over enforcing will. So what are the usual issues or disputes surrounding wills? Here you have formalities which are not met, lack of testamentary capacity, you have fraud and forgery, you have undue influence, you have suspicious circumstances, and also a possible scenario where the executor refused to obtain probate. So as I mentioned earlier, the Wills Act govern the construction of the will. So what are the formalities of a will here? So first, the testator or the will maker must have the intention to make a will. He or she must be 18 years above, and no will shall be valid unless it's in writing and executed in the manner prescribed under Section 5 of the Wills Act. So Section 5 of the Wills Act provides that signature of the deceased or the will maker has to be at the foot of the will, and it has to be witnessed by 2 or more witnesses. So that is the manner prescribed under Section 5. And under Section 4 of the Probate and Administration Act, the will maker will need to have executor or executors to execute the will. So here, 4 sub 1 provide a maximum of 4 persons. So in this case, Moy Yok Lai against Ivan Ho Tiong Yin, here the formalities are not met. So what happened here was the deceased had a will and appointed 5 executors and trustees in her estate. As I mentioned, under the Probate and Administration Act, the maximum executors or trustees you can appoint is 4. Unfortunately, in this case, the grant of probate was coincidentally issued to all 5 executors and also the trustees. The plaintiff in this case, who has the power of attorney granted by the deceased, applied to remove all 5 of the executors and also the trustees on the basis that they are not performing and they have not followed or acted in accordance to the deceased will. So in this case, the court held that, yes, it's true that the will contravenes Section 4, because under the Probate and Administration Act, only a maximum of 4 persons could be jointly be granted probate over the will. So in this case, the court didn't allow the plaintiff to be the sole executor, because in this case, the plaintiff applied to remove all 5 of them and to replace her as the sole executor. But the court did not do so. Yes, even though the will had 5 persons, so the court only removed 1. So the court removed the 5th defendant on the basis that the 5th defendant did not play a prominent or active role in administering the estate. The next common issue would be the lack of testamentary capacity, which means the deceased, while executing the will, did not have the sound mind or understanding as to what was actually done. So in order to prove that deceased lacked the testamentary capacity, of course, the most basic thing you need to show is that there is a medical report to show that at the point in time when the will was executed, this deceased or the testator was unsound of mind and lacked the mental capacity to make the will. For example, the deceased suffered from cancer, which is of ill health or imperfect memory. That itself is not good to challenge the testamentary capacity. So if the deceased or the testator is forgetful, that itself is not a good ground. If the deceased suffers from Alzheimer, as an example, then that is a good ground to actually challenge to show that the deceased doesn't have sufficient capacity to make the will. Next, we'll get into forgery. This is also one of the most common element or reason for dispute. Here, the testator's signature does not bear the true or original signature of the deceased. So this is where the forgery takes place. And this allegation is most commonly raised in situations where there are 2 wills. So in order to challenge a will that is being forged, we have to get the handwriting expert or forensic expert to come and give scientific evidence to prove that the signature does not belong to the testator. So in this High Court case of Chen Keng Pong against Chong Keng Huat, the issue before the High Court was whether the signature on the second will belongs to the deceased and whether the second will is a forgery. So simply just to say, there were 2 wills, and the issue was whether the second will is a forgery. So in this case, both the plaintiffs and also the defendant engaged or appointed experts to testify on the signature on the second will. So the High Court judge was in agreement with the plaintiff's case, and upon considering all the elements and also the expert evidence that was given, the court held that the signature on the second will to be most probably not of the same authorship of the deceased, but is most probably forgery. It went to a very technical consideration as to the strokes, the number of samples that was given, and in order to consider whether the signature belongs to the deceased or otherwise. Yes, so when it comes to terms of allegations of forgery, the plaintiff and also the defendant will most likely have to produce expert evidence to, one, of course, is to prove that it's not the deceased signature, and one will have to prove, of course, is the deceased signature. Next is on undue influence. So undue influence is not bad influence, but a form of coercion. So basically, a third party coerce or a beneficiary coerce the testator into preparing the will for the risk benefit. So here, persuasion and advice itself do not amount to undue influence. So long there is free volition of the testator to accept or reject them is not invaded. So here, basically, what it means that the testator does not have the will to actually, or the volition to actually prepare according to his own wish. Undue influence basically means that this is not my wish, but I must do it. So I give an example would be, maybe I hold on to or I don't allow the testator to actually get out of the house until certain conditions, for example, in the will, to be done. So in order for him to get out of the house, the testator has to agree with what I want. So that itself is an undue influence. So in this case where the court held that the testator was coerced into executing the will in the form that he had taken, or the will was not the voluntary act of the testator, it means that in order for the will to be able to probated and not being challenged, the will has to be voluntarily made by the testator. Next element in challenging a will would be suspicious circumstances. This is a very interesting element. It could be anything, and it's usually very factual, and it really depends on what has transpired, and it could mean a narrative of what has happened before in order to determine whether there were suspicious circumstances. But the suspicious circumstances here would be surrounding the execution of the will and not surrounding the testamentary capacity of the testator. So a usual case of suspicious circumstances would be substantial gift to a person who prepared or was closely involved in the preparation of the will. And the best way to actually dispel suspicious circumstances is always to get professional advice or assistance when it comes to drafting a will. This is a very interesting case on suspicious circumstances, and it's a very recent case. The plaintiff sued the defendant to invalidate a will that was prepared by the husband. What transpired was the defendant prepared a will, or rather the defendant was a substantial beneficiary under the deceased will. And the defendant actually prepared the deceased will on the basis that she has attended course and she had knowledge on how wills should be prepared. Of course, there are other issues here, but I try to focus on how the court actually came to the suspicious circumstances finding. At the point in time when the deceased actually prepared the will, the deceased was suffering from the end stages of blood cancer. In that state, while the will was executed, the defendant, together with the deceased and two witnesses, traveled all the way to Teluk Dato Court to get an officer of the court to witness, as in to see them, not to sign on the will, but to see four of them there and sign the will. But the court refused to do so. What happened was then they traveled all the way to Banting to look for a law firm, which was apparently known by the deceased, and to get them to actually witness the signing of the will. But when they reached Banting, they couldn't find the law firm. So then after that, they went to Bukit Tinggi to a law firm to actually get the lawyer to actually witness against the signing of the will or the execution of the will. However, the lawyer declined on the basis that they wouldn't be witnessing the will unless it was prepared by them. So upon being brushed off, they all went back to the company, which the defendant is the director, to actually execute the will. So all in all, they went on 3 hours around Selangor, basically, to get the will executed, which was not necessary. And during trial, evidence was also given where the two of the witnesses that actually signed the will, their witness statements were identical. Hence, based on all these facts, which is, of course, there are other facts too, or findings, the court held that there are suspicious circumstances in the execution of the will. Hence, the will was set aside. Next, we also have a situation where, like I mentioned earlier, the executor refused to obtain probate. So here in this case of Mak Chi Chong against Rock Wills trustees Berhad, what happened here was the deceased had a will prepared by Rock Wills. and Rethual were named the executor and also the trustee of the deceased estate. However, the fee quoted by the trust company was exorbitant, was excessive, which then the husband, in this case, the plaintiff, was unwilling to pay the fee that was quoted. And because the plaintiff or the husband was not agreeable to pay the fee, hence the trust company here did not apply for probate. And that being said, of course, the trust company was also unwilling to resign as an executor and trustee on the basis that they have already been appointed by the deceased. Knowing that there was a deadlock, of course, then the plaintiff then made an application to court to remove the trust company from acting as the executor and also the trustee. So here the court held that there was sufficient cause to actually remove the trust corporation because the beneficiaries in the will, the young children or the minors. And the court also held that when it comes to the wishes of the deceased, no doubt they are sacrosanct, but it's not absolute in the matters of administration of estate. So the court will also have to consider the interests of the beneficiaries and also what are the exigencies in decided whether to remove or to maintain the executor. So here in this case, the court held that the beneficiaries' interests and welfare are of paramount consideration, hence they have the trust company removed. All right, so now I will share the screen to Daphne, and Daphne will then share on conflicts and also strategies in preventing estate disputes.
Thanks, Gan. Thanks for the introduction as well earlier, Kirthika. Okay, so I will be touching on conflicts arising from estate administration, but a little more on post-grant, meaning after the executor or the administrator has obtained a grant of probate or a grant of letters of administration. Okay, it is case studies, just sharing what happened in the legal cases. So in the first case here, Liga Fernandez, it involves an executor which was residing out of jurisdiction. This particular executor here was residing in England, and then the beneficiaries actually applied to remove him on the ground that he was not present. So even though here, the executor was a Malaysian citizen and had a permanent postal address in Malaysia, but then the court took into consideration that his continued absence from Malaysia for more than 12 months rendered him legally incapable of acting as a trustee under the Trustees Act. That the court thought that was a sufficient cause to revoke the probate and remove the executor from his office of executor and trustee. Generally, when an executor is named and the executor is residing abroad, is not always an issue, but if the executor has been residing abroad and has not been back to carry out their duties, then that might be an issue that the court will take note of. So in this other case, Kubu Gong also, there was an executor who resided in Australia, okay? But then after the testator passed away, he returned to Malaysia and made certain arrangements for the administration of his estate before then returning to his home in Australia. He also appointed solicitors as trustees. So the court actually thought that there was no sufficient cause to remove him as executor. So the court basically kept him as the executor, and the court decided that absence from jurisdiction of an executor is always available, has always done what needed to be done, even though there are some lapses through where he has done what he needs to do through solicitors who are not only were capable, but in circumstances were the most suitable. In those circumstances, it cannot amount to a sufficient cause for revoking the grant of probate. So ultimately, what the court sees is whether or not the executor actually carried out his duties, even though he's abroad. If you're abroad and you're able to make the necessary arrangements to make sure the welfare and interest of the estate has been taken care of, I believe the court will actually not remove the executors easily. So in other circumstances where the court might look at removing an executor or administrator would be in situations where there is a non-performance of duties by the executor or administrator. So in this case, Damayanti's case, the executor here failed to extract the grant of probate after 7 years, failed to take preliminary steps in the administration of estate, failed to render accounts or periodic accounts, failed to take appropriate steps to prevent the distribution of the assets, and acted hostile towards the respondents, basically the beneficiaries. Here, the Court of Appeal actually decided that there was enough material to support the allegations that the executor and executrix have not discharged their duties. So the court thought that there was sufficient cause to interfere with the wishes of testator. So generally, courts are very reluctant to interfere in what is stated in the will unless it's shown that the welfare, the interests of the beneficiaries have not been taken care of. This is a situation where we call a Saunders and Vautier scenario. So to give a bit of background, Saunders and Vautier is actually a case involving a trust. So the rule is what we call the Saunders and Vautier rule is where the court actually decided that where a beneficiary has an absolute and indefeasible interest and is of an adult age and of sound mind, and this group of beneficiaries are the sole beneficiaries under a trust, then this group of beneficiaries may demand or expect the trust to be terminated and for the trustee to actually transfer the legal estate to the beneficiaries before even the date stipulated in the trust. So let's say I have this trust and then I said the trustee, okay, so I'm the settlor. I say all these monies are to be held on trust for ABC. So they are the only beneficiaries under the trust, and then there's a trustee. If that is the situation, then there are circumstances where it would be allowed for the trustee to be removed from the equation and for the entire estate or the trust assets to be transferred directly to the beneficiaries, even though the trust say maybe this trust is to be carried on for 20 years. So that's in a trust scenario. So here is actually where there was a will. So in this Leong Xiao King case, the plaintiffs filed a suit and the issues were whether the plaintiffs have shown sufficient cause for defendant to be removed as executor and trustee under the will, whether the plaintiffs who were of age and of sound mind were competent to end the trust for sale. Here, the court took in consideration that there is no sufficient cause to remove the defendant as executor because the plaintiff's complaint did not provide a real basis to suggest that if the defendant remained as the executor and trustee, the estate will not be administered satisfactorily or that the welfare of the beneficiaries call for a change. Even with that being said, the court still took note that the beneficiaries were of age and independent and was together, the beneficiaries were entitled to the entire beneficial interest of the trust. So the plaintiffs were actually allowed to put an end to the trust under the Saunders and Vautier rule. In a different case, this B and others against and Rock Will's trustee. So here the will states to only grant the son of the testator the trust properties when he turns 35. So the will also stated that should the son not have the fortune to turn 35, the deceased clearly stated that the trust properties are to be given to the son's surviving children in equal shares. And if the son dies leaving no children, then the trust property shall be distributed in accordance with the manner of distribution of the residuary estate. So here, the court said that the principle of Saunders and Vautier cannot be stretched to apply to this case for termination of the trust. The difference here is because the son's interest in the property is contingent on him turning the age of 35. If you turn 35, then you will be entitled. So in a normal situation, maybe the trust just says, okay, maybe Rock Wills to hold whatever company to hold the trust assets for these people. So there's no condition precedent, to use the term loosely. So there's no condition to be fulfilled before the beneficiaries actually acquire this interest under the estate, which is not the case here. Even though on the face of it, in this case, the son is entitled to the entire estate, but because his interest technically does not arise until he turns 35, the court said he was not entitled to terminate the trust and have all the estate transferred to him prematurely, means before he turned 35. Okay, now let's look at strategies for preventing estate disputes. Just very briefly, our advice is to always engage professionals to prepare your will or even a trust to help you manage your estate, and then consider the appropriateness of estate planning insurance, basically wills or trust, and then strive for equal distribution. Yes, equal distribution meaning be fair to all your children and maybe spouses, so that they won't find grounds, even if they leave behind a will, they won't find grounds to actually try to challenge the validity of your will, or in some circumstance, they come up with a different will and say that it's been prepared by you. It's actually not, just so that they can try to get certain assets out of your estate. And then regular update and review estate planning documents. So if you have prepared a will like 20 years back, maybe consider updating your will. What we always advise clients is to make sure your will is comprehensive as well. Set out all, we have clients coming and saying that we just want to prepare a simple will saying that, okay, all my assets go to A, which is fine, provided that A knows what assets you actually have. If not, upon your passing, then A will have no idea where to start to actually gather your assets. So in situations like this, usually we'll help clients actually write to the banks and all that to check if they have bank accounts. But then if you have immovable property under your name, like you have a house somewhere, there's a very slight chance that your next of kin is going to find out if you have never mentioned it to them. So then the property just be lying there. Next will be resolving estate disputes. These are the scenarios that we encounter where people seek to challenge validity of the will. And then if there's an executor or if where there's no will and then there's a person, you would expect, let's say the wife or the son, expected to take up the grant. And then if they are not doing so, we have to issue citation for them to accept or refuse the grant. And then also certain scenarios would be to beneficiaries would actually try to remove the executors or administrator because they have not been performing their duties to administer the estate. And then in such circumstances, if you think that the executor or administrator has not been carrying out duties, then you might want to consider filing a probate or administration action. But again, the court, especially where there's a will, the court will not easily remove the executors unless you can show that there is really a clear mismanagement of the estate. That would be all.
Thank you, Gan and Daphne, for sharing your insights for our online talk today. I believe we have some questions to address, and I believe Mr. Martin has raised his hand. Mr. Martin, as informed earlier, if you could please place your question in the question box, we can then address any questions you may have. It's just so that we can address your questions, and then if we have any follow-up, it's easy on our end. The first question we have today is, could you explain further on trusts and living trusts? Gan, do you want to take this question?
Yes, I can take this question. Maybe I can just briefly explain just a brief explanation on what's the concept of trust. So a concept of trust is where the settlor, person who is making the trust, appointing a trustee to hold certain assets on trust for a group or certain beneficiaries. That is trust. So a trust can happen. What is a living trust is basically a trust that you created while you are still alive. And a testamentary trust is a trust which could also be created, which is incorporated into the will, so that this trust will take effect upon your demise. A living trust, which is created while you are still alive, could also then continue until your demise. So this whole purpose of the trust is really to preserve the wealth and to make sure that the beneficiaries who are going to benefit from the trust do not actually squander off all your assets, and that certain provisions are given like a monthly allowance to them so that they could actually still continue with daily expenses or even medical or education. I believe that explains trust and also living trust.
Thank you, Gan. Okay, we have a question from BH Ong, whether a will needs to be stamped. Daphne, perhaps you can take this question.
No, a will does not need to be stamped. It just has to be prepared in the manner stipulated under the Wills Act. As long as that's done, it should be valid and good to go.
We have one more question, but I'm not sure whether we can assist in this. What are the fees for setting a trust?
Yeah, I can take this question. What are the fees? We do not have a fee structure on setting up a trust. So I guess it depends on like a trust fund kind of trust. Then I believe the appropriate organization or body will be to get a trust corporation to assist you in managing the trust. The reason being, these trust funds could provide for investment and also growth. Hence why this is not something that the law firm can actually assist. Hence why you have to seek more advice from a trust corporation.
I believe we have one final question. Can one spouse automatically transfer the properties to the surviving spouse upon demise before transfer to children?
Okay, maybe I can take this. I'm not too sure what you mean by automatically transfer. I would think it's you have prepared a will. Your will can stipulate everything to be passed on to your spouse, yes. But then if you don't have a will, then under the Distribution Act, your spouse and your children would be entitled. Spouse will get, if I'm saying that if your parents are no longer around, then your spouse will get 1/3, your children will get 2/3. That's if you didn't prepare.
The question is, if the person is knowledgeable enough to write his own will, can he do so himself and just get it witnessed by two parties, or is one witness sufficient? So I believe there's two parts to that question.
Yes, I can take this one. Yes, if that person is knowledgeable enough to write his own will, yes, of course, he can do. And it has to be witnessed by two witnesses. You cannot have one. In the event you only have one witness, then there will be void. Hence why you require to comply with the formalities of the will under Section 3 of the Wills Act.
There's a question here. Instead of following the Distribution Act to get everyone to inherit, can a third party inherit as well?
I'll take this.
The third party not being the beneficiary.
Okay, if you have prepared a will, you can state anyone you wish to benefit from your estate. You can give it to your friend, you can give it to your spouse, you can give it to your parents. No restrictions on that. But if you didn't prepare a will, then the estate would be distributed according to the Distribution Act. So the Distribution Act only comes into place if the deceased person did not prepare a will, or the will is void somehow, or in certain situations where the will is prepared but it didn't cover all the estate. Let's say I have 10 houses, and then in my will I only mentioned 2 houses, and then the will doesn't have something what we call a residuary clause, then the 8 houses would fall under intestacy, meaning it doesn't fall under your estate under the will. And then if there's no such residuary clause, then the 8 houses will fall under the Distribution Act. So the Distribution Act is only where there's no will, or your will is void, set aside, or if your will didn't sufficiently cover all your assets under the estate. In preparing the will, whoever wants to prepare the will on their own, it's important to put in the residuary clause as well, to state that whatever that's not stated in this will specifically should go to this person, so that you won't be caught in a partial intestacy situation.
I see. Okay. All right. We have one question from Karen. Sorry.
Kirthika, maybe I can add on to what Daphne has shared. I believe in that case, which I believe that based on the question by HP Wong, if let's say in that case, if there's without a will, and based on the Distribution Act, the statutory provided beneficiaries are supposed to inherit, unless these beneficiaries they do not want, they basically relinquish their rights to these assets, and they decided to convey or give this property or these assets to the third party. Yes, they can do, provided they themselves relinquish. But under the law, this pool of beneficiaries that has been provided for under the DA, so they are the persons that are going to inherit the assets. Yes, I also saw a last question, which I can read out. Can a beneficiary in the will be a witness? The answer is no. Even the spouse of the beneficiary cannot be a witness of a will.
All right. Thank you, Gan and Daphne, once again for all your interesting input for today's talk. Unfortunately, that's all the questions we can take for today. Should you require further specific legal advice, you can contact our firm, and we do provide a 30-minute free legal consultation. Before we conclude, I just have a couple of announcements to make. Okay, first, please join us for our upcoming talks. The next one will be on the 31st of July. And the online topic is the online defamation and social media. And the speakers are Mr. Edwin Raj and Ms. Kirbashini. You can also scan the QR code on the screen right now to sign up for more MWKA online talks. Secondly, please do fill up our feedback form. The link to the form will be posted in the chat box as well for your ease of reference. You can also follow us on social media. We have a YouTube, Twitter, Instagram, LinkedIn, and Facebook account. As discussed previously, if you do require further specific legal advice, you can schedule a complimentary consultation session up to 30 minutes with our lawyers. You can either scan the QR code, you can scan the QR code to the link that will take you to the complimentary consultation sessions. Thank you once again to our guests for joining us today. We hope you had a great time today at our session and that today's session was informative and useful.